And then finally, there's a narrow little circle there, which is privilege. And the whole issue under privilege is that can't be compelled to be revealed in a court of law without your permission. And I've given you a link to a website, Jaffee-Redmond.org, which is a wonderful source for all kinds of confidentiality issues in mental health. How many of you are familiar with the Jaffee versus Redmon case? Just raise your hand. Some of you aren't, so I'm going to give you the capsule version of it. How many of you are familiar with the Tarasoff case? Okay, so you've all heard about Tarasoff, that psychotherapists may have a duty to warn when there's a threat of danger to a specific identifiable person. What happened in the Jaffee v. Redmond case was that Mary Lou Jaffee was a police officer in the Chicago suburb of Hoffman Estates, Illinois. And Mary Lou and her partner arrive on the scene of a domestic disturbance in a housing project parking lot. And they witness one man chasing another man across the parking lot with a raised knife. And Mary Lou was the closest to the altercation, and she pursued them. She identified herself as a police officer. She warned the guy with the knife to stop, and when it appeared to her that he wasn't stopping, she used deadly force, and he died. She shot him. As often happens when there's a police officer shooting, Mary Lou was temporarily relieved of her weapon, put on administrative duty, and told to go talk to a therapist. And she did. She went and talked to a social worker and got some benefit from that treatment, apparently. But a federal lawsuit was filed by Jaffee, Jaffee being the executor of the estate of the deceased man. Now, think quickly, state, federal. In state court, Mary Lou is okay because the state of Illinois granted privileged communications to one's psychotherapist. But Mary Lou was sued in federal court for a civil rights violation. Jaffee, on behalf of the estate of his deceased client, said that Mary Lou Redmond violated the client's civil rights by shooting him. Federal civil rights lawsuit. Mary Lou was white, the client was black, the man who was shot was black. And at the time of trial, they subpoenaed Mary Lou's social worker and wanted the social worker to testify about what went on in Mary Lou's therapy. Mary Lou did not waive her right of confidentiality, her privilege, and the social worker said, respectfully, Your Honor, I'm not going to testify without my client's permission. Illinois law provides a privilege. The federal judge said, you're not in Illinois, you're in a federal courtroom. There is no statute passed by the Congress of the United States that grants privileged communication to psychotherapists. So I'm not going to put you in jail, social worker, but I am going to instruct the jury that they may consider this something that's being concealed from them. The jury came back awarding financial damages against Officer Redmon and the police department. And the case was appealed to the U.S. Supreme Court, where in a 6-3 decision, the U.S. Supreme Court said, no, there is a federal privilege. The U.S. Supreme Court established a federal privilege. They essentially said that in situations like this, there was a reasonable expectation on the part of Officer Redmond that what she was talking about was privileged and that there was a societal interest. And part of the decision was written by Stephen Breyer, whose wife is a psychologist in Boston. And so maybe she had some influence on her husband, although we'll never know. Breyer didn't actually write the whole decision. It was written, I believe, by Anthony Kennedy. Interestingly, on the other side of the decision was late Chief Justice Rehnquist, Clarence Thomas, and Anton Scalia, the three most conservative members of the court at the time. And Scalia wrote a rather stinging rebuttal which is humorous if you want to read it, and if you ever do, you could type Jaffee v. Redmond into Google, and it will take you to the actual Supreme Court decision, and you can read the minority report. But one of the things that Scalia was saying is, look, we shouldn't be, as the Supreme Court, making new law. If Congress wants to give a privilege to psychotherapists, let them go ahead and do it, but we shouldn't be establishing that as a matter of policy. The next thing you know, people will want their conversations with their mother to be private. So you're just on notice now that there's a conservative majority in the court. Your conversations with your mothers may not be considered private. And here we have a little cartoon. I can't talk about my childhood. Before I left home, they made me sign a confidentiality agreement.